And Ms. Hill, in cause number 25, DCCR 0650, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of assault family violence by impeding breath or circulation. Sentence you in accordance with your agreement to a term of 10 years in prison, but I'm going to probate that. You'll be on probation for 10 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. One of those conditions is going to be that you enter and successfully complete this special needs safety program. That is intended to help you with everything that's going on in your life, any mental health treatment you need, as well as substance abuse treatment, so that when you get out, you'll be better equipped to be successful on this probation. And so if you do everything that you're supposed to on this probation, then for all practical purposes, your case here in court is over, and you'll be able to serve that 10-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you can be brought back in here and you'll be looking at that 10-year sentence that you've already agreed to. Do you understand? Also, it's very important that you understand you can have no contact or communication with Cheryl Johnson. That's in person, that is electronically, through messages or anything like that. Do you understand? And even if she gives you permission and says, oh, it's okay, I'm not giving you permission, and that's how that has to work. You understand? All right, so I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your rights to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. And so Mr. Hancock is charged in 25 DCCR 0737 with evading arrest or detention with previous convictions. Cause number 25 DCCR 0738 with continuous violence against the family. And then there's a third case. Those both have offense dates of April, well, the first one is April 22nd of 2025. The second one is April 26th of 2025. And then in cause number 25, DCCR 1233, there's a new evading arrest or detention with previous convictions from August 5th of 2025 that has now been indicted. And Ms. Holmes has filed motions in the first two cases asking that I reduce Mr. Hancock's bonds, which are currently set at $100,000. It looks like there was a court date on July 22nd of 2025 that Mr. Hancock missed, and so that was when those bonds were increased.
On July 22nd?
Mm-hmm.
Okay.
And then, so he missed court on that date. So there was, before that, there was an AFRS that was filed by the bondsman to get off the bond. But when he didn't show up, the bond forfeiture overrides that. And so that was the bond forfeiture. And then also, since then, there was a request for an emergency protective order. Oh, that was just filed in the case. Okay, it looks like that was from back in the arrest on, where's the date? April 26th. Okay, so I'm also reviewing jail incident reports that I have received. Have you had an opportunity to review those? Yeah. Why don't you take a look at those, and then before you try to make arguments on behalf of your client who's making things very difficult for you, y'all can go review those, and then we'll come back and discuss
Judge,
the
I think
bond.
if you just let me review his criminal history, the decision will be very easy.
I've already know what I'm going to do, but I'd be glad for you to do that as well.
Yeah,
Okay.
he's habitual on this continuing violence against the family case. He has a total of, I believe, 10 prior felonies. And on these two evadings, the state jail and evadings with prior evading convictions, he has a total of 7 evadings. And the most recent one was picked up when he was arrested in August while he had warrants for these pending cases. His priors that are not evadings include firearms, drugs, and burglary.
Okay. Ms. Holmes?
He had only been off of parole about 2 months before the new offense date in April.
What is that? Let me look at something else that's new. I want to see what the bond is set at on the new case 25 DCCR 1233. Because honestly, based on everything I'm seeing, I'm not sure the bonds are satisfactory. We'll see. So Ms. Holmes, any
So, Your Honor, I was provided some documentation. Apparently, Mr. Hancock did go to the hospital in July, which I believe at the time he did provide that documentation to the bondsman. I'm not sure if he was aware that an AFRS had been filed at that point. He is aware that he needs to behave in the jail.
really, you're aware of that? How old are you?
I'm 36.
You're 36 years old, so you needed to come here today and have her tell you you need to behave in jail?
No,
This is ridiculous. These people are just going to work and trying to do their job. That's all. You know, I mean, that's what the rest of us do. We go to work, we do our job, we go home, we live our lives, and we don't have punks like you acting like this and treating us this way when we're at our job. The way you have spoken to the officers, the female, they disrespect you first. Do you think you earned their respect? You're in jail. You follow the rules. Their job's just to do their job. If it's time, you don't get to make decisions in jail. You don't get to decide when you turn the lights on and off. You don't get to decide when you go to bed or when you eat. It's not your decision anymore. That's what happens when you continue to violate the law. You've lost your right to make those decisions. So it's their decision to try to keep everybody in order out in the jail the best they can. And the way you have spoken to them and threatened them is actually a violation of the law, and you could end up with more cases for threatening a correctional officer. So just keep going, keep stacking it up. I'm sure a jury later will love to hear all of that. They'll love to hear it. You're looking at 25 to life on one of your cases. Keep it up. Let's see what happens. Because a jury will see all of this. And if you think I'm going to take some great deal that they're going to negotiate, or you think Mr. Nichols is going to give you some great deal, it's not happening. So you're old enough to know better. I'm going to deny the motions for a bond reduction in cause numbers 25 DCCR 0737 and 0738 based on several factors: your criminal history, the fact that you did miss court, the fact that your bondsman had already filed an AFRS, your jail incident reports. I am also going to find in cause number 25 DCCR 1233 that your bond is insufficient. And in that case, I'm going to raise your bond to $100,000. A condition of all of these bonds, if you make them, will be that you will be required to wear a GPS monitoring device, and you will be on house arrest. So if you make these 3 bonds, you will be on house arrest. You're not allowed to leave your house unless you have my permission. And you will be also ordered, and it should already be in a bond condition in cause number 25 DCCR 0738, to have absolutely no contact, no communication at all with the complaining witness. Do you have that name handy?
I do, Your Honor.
Janaisha Butler.
Janaisha Butler?
Jamaisha.
Jamasha.
So you cannot have any contact whatsoever with that person. Do you understand? That also includes when you're in jail. So there's no sending messages through that email system or anything like that to her through anybody else. That'll be a violation of your bond, and your bonds will end up raised even more. You understand? All right, I'll reset it for a for an announcement. We'll deal with all of the cases at that time.
Thank you, Your Honor.
Thank you. Mr. Godinez, in cause number 24, DCCR 2040, you're charged with the second-degree felony of aggravated assault with a deadly weapon from August 29th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they charged you with?
Yes.
I have here on the computer some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Wilkerson?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
I understand.
Also, do you understand, if you're not a United States citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
I understand.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Godinez is not competent?
No, Your Honor.
Mr. Godinez, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 12 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will be an affirmative finding of a deadly weapon. I'm going to hand you the trial court certification. This shows that this was an agreement that I followed, and so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. That's in Spanish, so you should read it carefully. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or how long that lasts, you can talk with Mr. Wilkerson. Yes, sir.
We've included in that complete paperwork that the sentence in this case run consecutive to the federal sentence. I know you don't necessarily have any control over that. The only reason why we included it is because Judge Crone on the federal side ordered it.
Okay,
So
so consecutive.
consecutive.
And so, Mr. Godinez, I want to make sure you understand that this sentence will run consecutively with any federal sentence that you're serving. Do you understand?
Yes.
All right, thank you. You can go back with the bailiff.
Thank you, Your Honor.
Thank you, Ms. Burge. Dalvius Williams. Good morning, sir. You're Dalvius Williams. And Mr. Williams is charged with injury to a child, elderly, or disabled individual in cause number 25 DCCR 0176. And what is the announcement?
Your Honor, if we could get just one more reset on this case. My client wasn't aware, because the priors aren't listed in his indictment, that the state would move for or give a notice of intent on extraneous offenses if this goes on to trial, increasing the punishment range. His admonishment, because I assume they weren't in the indictment when he did a plea rejection, was for 2 to 10 rather than 2 to 20.
Okay.
So I believe the state would stipulate he has one 8-year sentence in TDC and one state jail conviction.
Okay, and I don't see that that's been filed yet, but I will give you some time if you want to go ahead and get that filed so it's on the record, and then we will reset it. And so, Mr. Williams, you can go over with Mr. Wilkerson what the possible consequences are if you go to trial based on any criminal history and what your options are, and we'll get an announcement at the next court date. All right, you can go back with the bailiff. And are we only going on, I guess the two priors are on the same date, so those would, well, they could enhance. Are we going on count one with the prior, just for enhancement purposes, I mean, for, I guess, jurisdictional purpose, not the other two?
Yes, Judge, with the court's permission, I know there are obviously priors.
They're
from
old.
quite a bit ago in Orange County, and the theft in this case was $20 worth of food from the HEA that she concealed in her purse.
Good morning, are you Joyce Daigle? And will your client waive the formal reading of the indictment? Ms. Daigle, in cause number 25, DCCR 1054, you're charged with the state jail felony offense of theft with previous theft convictions from June 5th of 2025. The indictment alleges you were previously convicted of theft November 8th of 2001 and then again December 1st of 2006. And how do you plead to that charge? And are those two prior convictions true? Did you enter your plea of guilty and true freely and voluntarily? And did you plead guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Daigle is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of theft of property, find those two prior convictions true, and sentence you in accordance with your agreement to a term of 10 months in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. Good luck to you, ma'am. You can go back with the bailiff. Good morning. Are you Kadesha Eli?
Yes, ma'am.
And will your client waive the formal reading of the motion?
She does, yeah.
Ms. Eli, best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. And will she waive the formal reading?
She does.
I already said that, didn't I? Okay, Ms. Eli, in cause number 23 DCCR 0066, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation March 19th of 2024 for the second-degree felony offense of injury to a child, elderly, or disabled individual, and that was a 7-year deferred probation. Is that correct? It alleges that you violated your probation. Count 1 alleges that you committed the new offense of theft with prior theft convictions, July 7th of 2025 in Orange County, Texas. And is that true or not true?
True.
Count 2 alleges that you failed to report as directed to the probation department May 19th and July 22nd of 2025. And is that true or not true? Count 3 alleges that you failed to work faithfully at suitable employment and provide verification of that to probation. Is that true or not true?
True.
Count 4 alleges that you failed to remain in Jefferson County and that you were in Orange County July 7th, 2025 without permission. Is that true or not true? Count 5 alleges that you have failed to provide verification of performing community service hours as required. Is that true or not true? It goes from 5. Oh, there it is. Count 6 alleges that you failed to provide verification.
One through 8 are the same counts on each. 9 and 10 are different on each.
We have
Great, we'll agree to abandon count 4, that's the 10.
I'm printing the other one too, just because it's going to be hopefully easier and hopefully it'll print. It should be on its way. All right, sir, in cause number 24, DCCR 1791, I also have a motion to revoke your unadjudicated probation. This one shows you were placed on probation September 24th of 2024 for theft of a firearm, a third-degree felony, and that was also a 5-year deferred probation. Is that correct? Each of these cases allege that you violated your probation. Count 1 in each case alleges that you committed the offense of unlawfully carrying a weapon May 12th of 2025 in Jefferson County, Texas, and is that true or not true? Count 2 in each case alleges that you committed the offense of unlawful carrying a weapon May 25th of 2025 in Jefferson County, Texas, and is that true or not true? Count 3 alleges that you committed the offense of a minor in possession of alcohol May 25th of 2025, and is that true or not true? And then the state is abandoning 4, correct? In each case. Count 5 in each case alleges that you committed the new offense of resisting arrest or transport May 27th of 2025, and is that true or not true? Count 6 in each case alleges that you failed to report as directed to the probation department February 10th and May 15th of 2025, and is that true or not true? Count
Just technical, so we can.
All right, state abandons 7 through 10 in each case.
No objection.
Did you enter your pleas of true in each case to counts 1 through 6? I'm sorry, minus 4. So 1 through 3 and then 5 and 6. Did you plead true to those freely and voluntarily? And did you plead true to those counts because they're actually true? In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed those, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you've reached in each of your cases, that you will be waiving or giving up any right to appeal? State tenders number 1 in each
No
case.
objection.
It's admitted in each case. Is there any evidence that Mr. Williams is not
No,
competent?
Your Honor.
All right, sir, I'm going to find that you entered your pleas of true and in each case freely and voluntarily to counts 1 through 3 and 5 and 6. Find those counts true. Find sufficient evidence in each case to find you guilty. In cause number 23, DCCR 1801, finds you guilty of evading arrest or detention with the use of a vehicle, sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 24, DCCR 1791, find sufficient evidence to find you guilty, and at this time find you guilty of theft of a firearm, third-degree felony, sentence you in accordance with that agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm going to hand you in each of these cases trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I'm also going to hand you, and you need to listen carefully to this one because I'm not sure what's going on with you and all this gun stuff. Apparently you think it's cool to steal guns, have guns when you're not supposed to, and it's landed you now going to prison at, how old are you? 20 years old. You're going to prison because you can't keep your hands off guns, really. So because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. If you possess a firearm or ammunition, charges could be filed against you, and those charges are third-degree felonies. So it's no more UCW, unlawful carryings. It's a third-degree felony, felon in possession of a firearm, because you're now a felon. Do you understand? If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right, I'm handing you the trial court certification in that document now. I'm also going to sign, as part of the agreement, a dismissal in cause number 25, DCCR 0868. All right, you can go back with the bailiff. Good morning, you're Can Min Nguyen. And Mr. Nguyen, you were previously in court in cause number 25, DCCR 0750, and entered a plea of guilty to burglary of a habitation. I've received that pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Yes, sir.
Are there any additions or corrections?
No, just a request.
Ms. Holmes?
Yes, Your Honor, after I reviewed the PSI with Mr. Nguyen, we do see that the probation's recommendation is for him to enter and complete the cognitive track of ISF. Mr. Nguyen did ask me to recommend if possibly the court could hold it in abeyance. He does have a plan to enter into a residential treatment program called South Point upon release for probation, so that he can stay on top of or to maintain some sobriety, because I believe that's the root of a lot of what's going on involving him with his family and past history. And so we were requesting if the court could consider holding the cognitive track of ISF in abeyance and allow him to enter into that residential treatment program.
So here's what I'm more inclined to do, is I'm going to order the substance abuse track of ISF instead of the cognitive, if that's the main issue. And there's, I would rather that be that intensive inpatient in custody treatment, and then when he gets out, if there is a treatment that probation will approve for aftercare, that's fine. Otherwise, he'll do the aftercare that's part of this, but you can talk to probation about that. But with this history, with what's been going on, and the fact that you continue to do this to your mom is what is very concerning. Sounds like she is pretty fed up, and probably for very good reason. So anything else?
No, Your Honor.
Okay. So what I'm going to do then, Mr. Nguyen, is I'm going to follow the agreement that you made with the district attorney. I'm going to defer all proceedings, place you on probation for a period of 8 years. You're ordered to pay a $500 fine, and you're ordered to enter and successfully complete the substance abuse track of the ISF program. And then for aftercare, you will do whatever aftercare probation deems appropriate. If there's some other program that you want to still go to, you can talk to them about it, but it has to be approved by them and by me, all right? We want you to get the help you need, but I want it to be right now up front and in this program. When you're out, you will be on the high medium caseload, which means at first your probation is going to be you're showing up more, you're getting drug tested more, and following through with everything that you're supposed to on this probation. That also includes not having any contact with your mom. That's in person, that is through calling or texting or anything like that until further order of the court. Do you understand? If you do everything that you're supposed to, get your life on track, take advantage of this that you're getting today, then this is an excellent opportunity because you do not have a felony conviction on your record. And at the end of the probation, you will actually, if you do it successfully, the case will be dismissed. You'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you'll be brought back into court. You could be found guilty of the offense, so you would become a convicted felon, and I could sentence you to prison for anywhere in the range of punishment, which is up to 20 years. Do you understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I think that's any other, I was looking at the conditions to make sure there was nothing else. Obviously, you're also not to be anywhere around 5080 Helbig Road. So if you need to go somewhere, you go a different direction.
What is it, address?
Is that not your mom's address?
I think that was that